Good morning. Welcome to my channel Vidyapeetham. Joy of Learning. Hi, I am Nageshwari, Assistant Professor. So, in the past videos, we have discussed about the introduction of human rights and as well as origin and development of human rights. In this video, we will going to discuss about the notion and classification of human rights, the difference between the fundamental rights and human rights, then difference between the duties and rights and the types of human rights. First, we are going to discuss about the notion of rights. So what is meant by the notion of rights? That is a conception of or belief about something is called as notion of rights. The specific enumeration of rights has differed greatly in different period of history. In many cases, the system of rights promulgated by one group has come into sharp and bitter conflict with that of other groups. In the political sphere, a place in which rights have historically been an important issue, constitutional provisions of various states sometimes address the question of who has what legal rights. Historically, many notions of rights were authoritarian and hierarchical, with different people granted different rights and some having more rights than others. For instance, the right of a father to be respected by his son did not indicate a right of the son to receive something in return for that respect, and the divine right of kings, which permitted absolute power over subjects, did not leave much possibility for many rights for the subjects themselves. In contrast, modern conceptions of rights have often emphasized liberty and equality as among the most important aspects of rights, as was evident in the American and French revolutions. Or the notion of rights. Now, we will see the small symbolic representation of origin of rights. Yes, the first one is natural law, then comes the natural rights, and then comes the finally human rights. Now, next we are going to see about the difference between the fundamental rights and human rights. Actually, both the rights are same, but there is a little slight difference between the fundamental rights versus human rights. Fundamental rights includes only those rights which are basic to a normal life. As against this, the human rights are based on the right of life with dignity. Fundamental rights are guaranteed under the constitution of the country, whereas the human rights are recognized at international level. So these are the major difference between the fundamental rights and human rights. Now comes the fundamental rights. There are 6 categories of fundamental rights. The first one is right to equality. This was discussed in the article 14 to 18. Second one is right to freedom. This was discussed in the article 19 to 22. Right against exploitation. This was discussed in the article 23 to 24. Right to freedom of religion. This was discussed in the article 25 to 28. Cultural and educational rights. This was discussed in the article 29 to 30, and finally right to constitutional remedies. This was discussed in the article 32 to 35. These are the 6 major fundamental rights was declared in UDHR. Now, Next slide is about rights versus duties. So what is the major difference between the fundamental rights and as well as fundamental duties? Let me check the different points. The first one, the fundamental rights applies to both citizens and foreigners. Fundamental duties apply to only the citizens. Fundamental rights are justiciable in nature. That is, they can be taken to court of law if they are not allowed. Fundamental duties are non-justiciable in nature. They can't be taken to court of law if they are not followed. Fundamental rights are legal sanction and direct enforcement, but Parliament can suspend it if these are not guaranteed through proper legislation. Fundamental duties lack legal sanction and direct enforcement, but Parliament can enforce if it wants via proper legislation. The fourth difference is fundamental rights have impact on the government. Fundamental duties have impact on the citizens. Next difference is rights are what we want others to do for us. The duties are those acts which we should perform for others. These are the major difference between the rights and duties. Now, in addition to that, we can see the simple difference between the right, responsible and duty. The first one is right. What is meant by right? That is a moral or legal entitlement to have or obtain something or to act in a certain way. Responsibility. That is the fact, state or position of being accountable to somebody or for something is called as responsibility. Then what comes the duty? So duty is an obligation or something that somebody is obliged to do for moral, legal or religious reasons. So this is the a simple explanation of right, responsible and duty. Now next one is we are going to see the typical classification or we can say types of rights. So there are some important types of rights. The first one is natural rights. Second one is moral rights. Third one is legal rights. Fourth one is civil rights. Fifth one, political rights. Next, economic rights. Next, social rights. Next, cultural rights. Then finally, collective or solidarity rights. Now, in this picture, it is clearly shows the our right to education, right to assembly, right to association, right to movement, right to religion, speech, information, press, thought. All these rights comes under the categories of these types of rights. Now, the next one is the typical types important. So, apart from these, all these 8 to 9 classifications of human rights, the UDH are classified into these 5 major categories. That is, so human rights are traditionally categorized in the following 5 types. Human rights are derived from the principle of natural law. They are neither derived from the social order nor conferred upon the individual by the society. They reside inherently in the individual human being, independent of and even prior to his participation in the society. Consequently, they are the result of recognition by the state, but they are logically independent of the legal system for their existence. Their origin may be sought in the natural law and not in the positive law. They are based on their intrinsic justification and not their enactment or recognition by certain individuals. They do not depend on any formulation or accepted authority. The French jurist Karl Wasek was classified human rights as under these five categories, that is civil rights, political rights, economic rights, social rights, and cultural rights. So these five rights are the traditionally categorized by the UDHR. So finally, they categorized as solidarity rights. Now, next, additionally, in this video, we are going to discuss about the three generation of human rights. There are three generation of human rights starting from the uh, 16th century to till 20th century. There are three categories. The first generation, second generation of human rights, and third generation of human rights. Now, let me see what is meant by first, second, and third generation. First generation of human rights. The first generation of human rights are those which originated in Europe and America in 18th century. These rights emerged from the American Revolution 1776 and French Revolution 1789. The 17th, 18th and 19th centuries contributed and strengthened the civil and political rights which assured civil and political liberties. They were aimed at securing the citizens' liberty from arbitrary action by the state. These rights correspond by the large to the civil and political rights in the International Bill of Rights, such as the right to individual freedom, freedom of speech, thought and faith, the right to own property, and so on. These rights were meant to impose negative obligation on governments to desist from interfering with the exercise of individual liberties. These rights were among the major concerns of all liberal and democratic movements since the 19th century. The civil and political human rights are collectively known as liberty-oriented human rights because they provide, protect, and guarantee individual liberty to an individual against the state and its agencies. So, the first generation of human rights, or we can say it as a civil and political human rights, are collectively known as liberty-oriented human rights. Liberty rights are also referred to as blue rights or the first generation of human rights. Yes, I repeat, liberty rights are also referred to as blue rights or the first generation of human rights. We are going to look at the second generation of human rights. The second generation of human rights emerged in the 19th century out of the political and economic struggles of the emergent working class and included political and economic demands like the right to participate in the exercise of political power, the rights to universal adult franchise, the right to fixed hours of work, the right to minimum wages, the right to form unions, and so on. The 20th century contributed to the development and strengthening of economic, social and cultural rights and the rights of minorities as well. These rights were conceptualized and legalized in the West in course of a series of agitation and struggles corresponding to the various stages of economic growth under a capitalist system. These rights are also said to be security oriented as it provides for social, economic and cultural security. So, these rights are also said to be security oriented. These rights, social, economic and cultural, are more positive in nature, that they make it the duty of the state to ensure that these rights are realized. The Universal Declaration of Human Rights reflects the consensus on the principles which form the basis of the first and second generation rights. Continuation with the second generation, these rights aim at promotion of the economic and social security through economic and social upliftment of the weaker sections of the society. These rights are essential for dignity of personhood as well as for the full and free development of human personality in all possible directions. These rights ensure a minimum of economic welfare of the masses and their basic material needs recognized by the society as essential to civilized living. Next comes the third generation of human rights. The third generation of human rights emerged in the 20th century through the socio-political turmoil of the two world wars. These rights are a response to the phenomenon of global interdependence. These rights are of relatively recent origin. They have evolved in response to various new concerns over which the international consensus has emerged in recent years. This includes environmental, cultural and developmental rights. They are concerned with the rights of groups and peoples rather than of individuals and include such rights as the right of self-determination and the right to development. The Declaration on the Right to Development adopted by the UN General Assembly in 1986 is the most important example of these rights. In continuation with the third generation, the development-oriented human rights are of a very recent origin in late 20th century. These rights enable an individual to participate in the process of all-round development and include environmental rights that enable an individual to enjoy the absolutely free gift of nature, namely air, water, food and natural resources free from pollution and contamination. These are known as the third generation of human rights, or we can call upon green rights. They are also called as solidarity rights because their implementation depends upon international cooperation. In this video, we have discussed about the notion, classification, types of human rights. Finally, we have discussed about the generation of human rights. Thank you all for watching this video.